Major breaking news out of New Mexico. The federal district court judge has entered an injunction, a temporary restraining order, enjoining the enforcement of the gun-related, Second Amendment-related components of Governor Grisham of New Mexico's order that essentially said you could not carry guns anywhere in Albuquerque or the relevant county. Good news out of New Mexico. Let's talk about it when we get back. There's a lot to learn. Hey folks, I'm Mark Smith, host of The Four Box Don, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the A to Z guide of how the anti-gunners intend to take away our rights. Check it out. All right, folks, great news today. We have a temporary restraining order that is going to last at least until October 3rd. That is enjoined the government, specifically the governor of New Mexico's order that says you cannot carry a gun even with a concealed carry permit in Albuquerque. That executive order, that public health emergency, so-called, has been enjoined by a federal district court on the grounds that this clearly violates NYSERPA versus Bruen and Heller versus McDonald. The judge made it really clear, and what's interesting, we often talk about this channel, the importance of understanding the role of inferior courts under Article 3 of the U.S. Constitution, and this judge basically said that because one of the arguments the governor's lawyer made, was that Clarence Thomas essentially got Bruen wrong in various ways, and the judge interrupted and says, hey, stop. I am not here to second-guess Bruen. It's not my job. Whatever Clarence Thomas said on the Supreme Court, I have to follow because I'm an inferior court judge under the Article 3. As a lower court judge, I must follow it, so I'm not get into a debate about NYSERPA versus Bruen, the right and the wrong here. It's not my role. And it's good to see a federal district court judge recognize their role in the constitutional scheme. There was no debate about that. Beyond this, what the government really argued is laser focus, trying to claim a bunch of it. Frankly, I thought the argument by the government was really weak. It really was the kind of argument I would expect to see in the op-ed pages of a newspaper and not actually in a court of law. For example, some of the arguments were made was really appeals to emotion. We want to protect the kids. We don't like gun violence. Things like this, that we don't want people to be beholden to the NRA. And I'm like, okay, none of these are legal arguments. And the fact is we have a constitution that is the law of this country. And in that constitution, it specifically says the right of the people to keep and bear arms. And I do think one of the things that the Second Amendment lawyers could have probably done a little bit better on is to really keep hammering home the fact that this is a constitutional right. And you cannot suspend a constitutional right in the name of a public emergency. And if you could do it for the Second Amendment right, you can do it for all the other aspects of the Bill of Rights. And what I might have also said if I was a Second Amendment lawyer is to go on to say, in fact, if you think about it, in World War II, in the infamous Korematsu case, the government and the Supreme Court signed off on an emergency that allowed them to intern in camps American citizens of Japanese descent. So the reason why I bring this up is because if you think about it, that is exactly the argument being made by the governor here. Because it's an emergency, you can suspend constitutional rights, which is exactly what happened in World War II with American citizens of Japanese descent. They were literally put in camps. I might have even made that point in this argument to say, Judge, according to her theory, this is exactly what they would say is appropriate. That maybe we can only put them in camps for 30 days because this government kept saying today, oh, we just want to do this for 30 days so we can study the problem. Well, of course, we all understand that 30 days of a violation of constitutional right is totally unacceptable, irreparable harm, and I'm happy to say that the judge said exactly that. Beyond that, of course, it's simply stupid to think that another 30 days of studying gun-related violence in America is somehow going to be more significant and insightful than literally the decades upon decades of study that's already taken place, and none of it matters because we have a constitutional right to keep and bear arms, and the Supreme Court has repeatedly says in Heller and in Bruen that, look, the bottom line is balancing test, interest balancing, none of this matters for constitutional rights because we do not say because someone might violate the Second Amendment, someone might commit a gun crime, I, as an American citizen, lose my rights because it's what some psychopath criminal does. And what's very interesting is the government argument here was essentially to say we don't know who the good and the bad people are because they don't walk around with a t-shirt that says good guy and a t-shirt that says bad guy. So we have to basically assume everyone's a bad guy. That's essentially what if you look at the argument, what I think she was implying was because we can't figure out who the good guys are and the bad guys are, no one can have a gun. And that's why this government's order, the governor's order, should be upheld. That is very scary thinking that we're going to start again defining our constitutional rights by virtue of how they can be abused by criminals and psychopaths. But that is essentially what I thought the governor's argument really was. But let's carry on. There's another interesting thing here. I do think the Second Amendment lawyers did overall a good job, but I think they could have been a little stronger in a couple places, and maybe we'll do some videos about maybe how to improve in the preliminary injunction hearing. But for the moment, I think overall they did a great job and they won the case so far, and I think that's great. But there is some cleanup items I think can be could be done and improved upon. I do think that the Bruen case undeniably already resolved this. Keep in mind how hard, this is not that hard, right? You have the text of the Second Amendment. This is the right to keep and bear arms shall not be infringed. Here you have an order that says you can't carry guns. That implicates the right of the right to bear arms in the text of the Constitution. Once that text is implicated, the burden shifts to whom? The burden shifts to the government. And one of the things that I might have done as a Second Amendment lawyer is to literally sit there and be like, now I wouldn't have done this, but I could have said this. Look, Judge, I can literally sit here and do nothing. The burden is on the government to come forth with a historical analog at the time of the founding, or at any time, frankly. They can't even do it at any time where a governor could just wave the magic wand and get rid of the right to carry guns. That's not even available to them. But nevertheless, they have the burden to show, the government has the burden to show an analog. And the first thing I would have said is, have the government show us what analog, what historical analog law are they relying on today at this hearing? What exactly is it? Point it to me now that allows a governor to suspend the right to keep and bear arms right now. There's nothing there. And I might have really hammered that home because there's been nothing to say but humada, humada, humada. Or alternatively, the government would have been forced to say, there's these laws, and guess what? Any law that deals with restricting carry has already been brought forth and addressed by the United States Supreme Court in Bruen in the dozens and dozens and dozens of amicus briefs and party briefs and arguments and review by the Supreme Court in Bruen was all about restrictions on the right to carry guns in public. And Bruen says, guess what? You have the right to carry guns in public, period, full stop, under the Second Amendment. Any analog the government possibly could have come up with today at this hearing was already been dealt with by the Supreme Court and would have been like, hey, the court already considered that analog, goodbye-bye. But again, it doesn't matter because we won this, but at the preliminary injunction hearing, we may want to strengthen that up, and we'll talk about that in some videos to try to clean some of that up. The only other outrageous statement I thought, and there were several that I thought the government was made, it was weak T. Look, I understand from the lawyer's point of view, it was a very heavy lift. And the judge basically said, look, this is a heavy lift to defend what the governor did, your client. And trust me, I've represented plenty of people that had cases that were, shall we say, difficult to defend, and you do the best you can, and sometimes you lose because you don't have a good hand, you don't have a good case. And I understand that the lawyer for the governor was working really hard and trying her best, but of course it just wasn't good enough and she had a losing case. But she did try to say that at the time of the founding, domestic violence was not a problem, it wasn't abuse. That is not true, not true. We're going to see, I suspect, in the briefing of Rahimi, that if you go back to 1791, domestic violence was entirely frowned upon. It was considered verboten. It was not permitted. Do not kid yourself that you could not engage in beating up women or anyone at the time of the founding. That was understood to be a no-no, a malum in se, meaning evil in itself, crime. So I'm sure that will all get litigated in the Rahimi case. But this lawyer for the governor tried to say that at the time of the founding, well, beating wives or engaging in domestic violence was not a problem, not viewed as a problem, and therefore Bruen and the historical analog method is somehow not adequate. But again, that is simply not true on a whole lot of levels, but that is an argument the government made. All right, folks, so I'm not going to belabor this. We can talk more about this because the bottom line is we won the TRO until October 3rd. October 3rd is when the next hearing is going to be. That's the preliminary injunction hearing. Between now and then, we'll probably do a little bit more deep dive on some of the arguments we may see at the preliminary injunction hearing. One argument might be is whether or not, what is the governor going to do? Is she going to withdraw this order, issue a new one, just withdraw it and walk away? Or is she going to fight this to the death? Only time will tell. We will see. But in the meantime, it is a great day for the Second Amendment. Congratulations to the organizations, the National Association for Gun Rights, the Second Amendment Foundation, Firearms Policy Coalition, Gun Owners for America. Great victory for all of you in the New Mexico Shooting Sports Association. We're very excited you're out there fighting the good fight, and we're glad you won today. And we suspect you're going to have more victories down the road. And again, congratulations to all involved, and another big day and a big win for the right to keep and bear arms in America. And all these little things add up, folks. They're all bricks in the wall protecting our rights. Every little win pays off big time. And I'm glad to say today we had another, not just a little win, but a big win. So great job, Second Amendment today in America. All right, folks, hope you haven't, if you haven't subscribed to the Four Boxes Diner, make sure you do. And don't forget to follow me on X at Four Boxes Diner. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.